Right, well, it's 10:02, so I think we'll get started. Welcome everybody to IP in Focus. We're going to be talking about patents this morning. I'm Mary Turonek, Principal with Wrays, working from their Perth office. And I note a few of you have sent in some questions as part of your registration process. I'll be talking to some of those questions and providing, hopefully with some answers, understandable answers for you as we discuss these issues this morning. But look, if you do have any questions that come to you in the course of the seminar, please jot them down on the Q&A function of this Zoom meeting, and they'll be very, very welcome at the end of the meeting. So if we were doing this face-to-face, I would have enjoyed it being a little bit more interactive, where we can go off on tangents and address questions as we go. We're a little bit more constrained in the Zoom format, but I'll be really happy to have those discussions with you in relation to those questions at the end of the presentation. Okay. Well, the theme of the talk was debunking some of the myths. I hope you're seeing page 2 of my slides. And some of those myths that we commonly hear are, we've got a worldwide patent, patents are worthless if you don't have the money to enforce them, or we'll just rely on trade secrets or being first to market, and you only have to change it by 10%. Well, all of those myths are really wrong. So we're going to debunk those myths and tell you a little bit about why those myths exist and why they're wrong, and give you a few tips about ensuring that if you do take your company down the path of securing patent protection for your technology, that you will have robust patents that will stand you in good stead as commercial tools to push your business forward, because that really, at the end of the day, is what a patent is. It's a legal and commercial tool to assist and support your business plans. Okay, so a patent is a monopoly right that's granted to the owner of invention that prevents others from exploiting the invention without their permission. It's actually a positive right to do something. Sorry, it's not a positive right to do something, but it's a right to exclude others from doing something. So the monopoly itself provides very broad commercial powers, in that the monopoly related to the invention includes not only making and using and hiring the invention, but importing it and exporting it out of a particular territory and selling the patented invention. But it also relates to making an offer to fabricate and use, an offer to hire, an offer to import and export or sell the patented invention. And that's a very broad, powerful monopoly over the use of that particular invention. A few years ago in the US, in the oil and gas industry, a Norwegian company made an offer of sale of a floating drill rig to a US company. And in the course of that commercial transaction, they discovered that there was an existing US patent, and the design of this particular floating drill rig would infringe that US patent. So they took steps to modify the design of that floating drill rig. It was engineered in Singapore and then sailed into the Gulf of Mexico. Now, the floating drill rig, the actual article, that was the ship that was flown into the Gulf of Mexico, didn't infringe that US patent. But because the original offer for sale included, was in relation to a drill rig that did infringe that particular US patent, the Norwegian company was found guilty of infringement of that US patent, not through the actual drill rig that sailed into the Gulf of Mexico, but the commercial transaction that had occurred and the value that was associated with that commercial transaction. Now, I think the second important point that I want to make this morning is that a patent is territorial, so that it's only in relation to activity that occurs within the country where the patent has been granted. So, okay, how does this relate to this particular case? What we have is a transaction that was taking place in Oslo through the Norwegian company. The documents were signed off in Oslo. The actual fabrication of the drill rig was performed in Singapore, and then it was floated into the Gulf of Mexico, into US territorial waters. Well, despite the fact that this transaction was very much a transnational transaction, the offer for sale, even though it had been made in Oslo, was directed towards activity that would be occurring in the US. So there was no extraterritoriality. It was very much a commercial transaction which was related to use of the invention in the US. So ultimately, it was found to be an infringement of that US patent, and the value associated with that transaction was awarded as damages. So going back to my second point, a patent is territorial. So if you want a patent in the US, you have to apply for a patent to be granted in the US. Similarly, if you want an Australian patent, you need to proactively file a patent application in Australia to obtain an Australian patent and elsewhere around the world. So there is no such thing as a worldwide patent. What some of you might have seen are patent publication numbers with the prefixes WO, which refers to an international patent application publication, which is given that prefix, but in no way is that publication able to be enforced worldwide. It's just an indication that the applicant has proceeded to obtain patent protection through what's called the PCT Treaty, which is the Patent Cooperation Treaty. It covers about 145 different countries. It's a streamlined application mechanism to obtain rights in different countries, but ultimately those rights are territorial and they are limited to whichever country you file patents in. Let's go to the next slide. Okay. So this gets on to our next part of the talk. In relation to a patent, there are two parts to the patent which are very important. There are the claims, which are really the crux of what the patent is all about. The claims define the monopoly in respect of the invention. So they define the essential features that make the invention function in the way that it does, and make it effectively novel, inventive, or innovative. So those are the two main criteria that those patent claims have to meet. Now, the sort of patentable subject matter that can be the subject of a patent would be an apparatus, a device, a thing, something tangible that you can hold, that you can build, that you can make. But it also relates to a process or a method, a system, and that might be a system of components that are available off the shelf. But because they've been configured in a particular way, which is novel and inventive and produces obviously advantageous results, whether that might be reduction in carbon dioxide emissions, or it might be increased production, things of that sort. If you can point to a technical advantage that occurs because you've arranged these known units together in a novel and inventive way, then that system is patentable. Compositions and formulations can be patentable, and that's a big sphere of protection for pharmaceutical companies. Obviously, at this time, they're looking at different formulations and compositions of medicaments that can be used in the COVID battle. But I'd also say that software is not excluded from being patentable subject matter. It's a difficult area to obtain patent protection, but there's certainly many patents have been granted in the field of blockchain, the Internet of Things, AI. I believe IBM is one of the largest filers of patents in respect of AI. I was back in Texas at the end of 2018 for a patent conference, an IP conference there, and there was a specific seminar devoted to patentability of software and blockchain. And at that time, I think IBM had in excess of 200 granted US patents in respect of that field alone. So we can't discount patent protection for software related inventions, but we do have to be very careful about the field that they're in and what they're actually achieving in order to be able to obtain a patent. One of your questions that came in earlier was, well, how do you patent a concept? And I'd say a concept, if it's just left in abstract terms, won't be patentable. A concept really has to be crystallized in terms of what it can achieve in practical terms, in a practical application of that concept. Then that's something that we can work with. And that's often the case with software. Initially, when we look at things and look at the original concept, you have to drill down a little bit deeper and look into, well, what is the practical application of that software in a particular field to obtain economic results and advantageous results. Something tangible is achieved, that software is able to provide that, then we may have something that's patentable subject matter. Okay, I want to debunk this other myth about, well, what is 10% of a claim? The picture that you can see on the left of the screen is a module for a floating water cover. And this invention relates to a series of these modules that are clipped together, and they effectively, you have 20, 30, 100 of them with adjoining edges that are floated on lagoons and ponds and dams to reduce water evaporation. Now, I'm not going to read that claim, and I don't want you to read that claim, but you can see that it is complex wording. It defines certain features in relation to the structure and function of this particular floating water cover. And it's a question of, well, how do you define what is 10% of this claim? It's impossible to do. So an assertion that, well, we'll just change 10% of it, or you can avoid it by changing it by 10% so the patent is worthless, doesn't really hold water. An infringement has to fall within the scope of the monopoly of what's defined in the claim. If it falls outside of the claim, it's not an infringement. If it falls within the claim itself, within the scope of that claim, then it is an infringement. And that's how the courts will regard it. Okay. The other part of the patent application, of course, is the description, which describes the invention and how it functions. And the description is really important. It has to be clear enough and complete enough for the invention to be performed by the person skilled in the art. It has to describe the best method of performing that invention known to the applicant at the time. And those claims have to be supported by the description. So it's not sufficient to say, well, we define a mechanism to get to the moon. You've really got to describe that mechanism and how it would enable somebody to fly to the moon. And look, there's been a string of cases in the Australian courts just recently where the claims themselves have met the criteria for novelty inventive step. But the validity of the patent has actually fallen down because the description wasn't robust enough and strong enough. There were flaws in the description. So laying really good foundations in respect of a patent application early on, even with the priority document, which for us in Australia is generally a provisional patent application, is an essential step in the patenting process, that you get these things right as far as you can and with as much as you with as much knowledge about the invention as is available at the time that you file that application. This sort of brings me to another question that somebody listed, was sort of, well, how do you tell if you're at a stage to file a provisional patent? Is it worth waiting until you have a clearer idea of your minimum viable product? And it is a very difficult question to answer. I think my point of view is that the decision to file a provisional patent application is, to a certain extent, reliant on how much about the invention do you understand and how closely you have brought it to that minimum viable product. But at the same time, most companies, most applicants are working within a commercial environment, and the commercial circumstances will also, to a certain extent, dictate the timing of that filing of the provisional patent application, of that first application, to stake your claim in the invention and get a priority date. Because there may be an impetus, a commercial impetus, to disclose the invention. There may be a requirement, if the invention, for instance, has come out of a university, in terms of a publication may need to be made, whether that's a PhD thesis or an academic paper. So that will be a driver to filing a provisional patent application before that public disclosure has been made. In the case of more of a commercial invention coming out of a company, well, it may be a commercial impetus to get a new invention or new piece of technology on the road and get it trialled. There could be a lot more interest in, you know, this early prototypes, commercial interest, than you'd initially assume. So you'd want to file a patent application as quickly as possible so that you could make the most of those commercial opportunities that had arisen. So I think there's a balancing between the development of the invention and the commercial drivers as well. And after all, this is what's all the patenting process is all about. It's about being subject to those commercial drivers and working with them and adapting to them to support that commercial strategy as best as possible. Okay, so we're going to focus a little bit now in the next few minutes about trade secrets versus patents. And that leads me to another question that somebody has asked. Well, should a synthetic method for production of a chemical composition be kept as a trade secret or instead disclosed as a patent? And that's an excellent question, and one that applicants wrestle with all the time. But I think if you've got an invention which inherently will become public, will be out there, will be used, and there's no way of being able to keep it secret, then you have to think very, very carefully about the risks associated with with relying solely on trade secrets. Because while you can, in some cases, put the technology in a black box and restrict access to it, eventually, well, the risk of it being reverse engineered is much greater, I think, when you've got something solid and tangible. You can get leakages through ex-employees, through subcontractors. The risk is much, much higher. So I think looking at patents as a form of protection of tangible objects, it lies heavily in favour of patents. When it comes to compositions, you know, Kentucky Fried Chicken's secret herbs and spices and Coca-Cola's recipe, I mean, they're famous examples of trade secrets which have been maintained over a long period of time. So it shows that it can be done. And I think the decision as to whether to keep it a trade secret versus a patent relates very much to your appetite for risk, because there are risks associated with keeping something as a trade secret. And most of those risks relate to the people who will be dealing with that information. So it will be ex-employees, it will be subcontractors, etc. And enforcement of those breaches of confidence, contracts, fiduciary duties, etc. Through the courts is certainly possible. But if you are solely going to rely on trade secrets, or to a large extent to trade secrets, then it's important, I think, that you have very good legal contracts within your organisation, within your employment contracts, when you bring on board people and when they leave the company, that it's made very clear to them about that, how that information should be dealt with, and that they don't deal with it. So you're really having to rely on legal mechanisms to maintain trade secrets and have management of that information to deal with the risk. With the patent, it's very true. You do have to disclose the invention to the world. But there are advantages to doing that. There's still an 18-month period in which information about the invention is kept confidential. So your application is not published until 18 months after the first application is filed. And I think we look to the example of pharmaceutical companies and others that, on the most part, for the important compositions and formulations and processes, they will have patents in respect of those. And they might keep trade secrets in relation to some of the peripheral issues, the secret herbs and spices, if you like, of some of the other things. But there'll be a mix of both trade secrets and patents in their portfolio. I think, which leads me to say, look, to patent or not to patent, I think it's important to make an informed decision. I think many people say, well, look, we'll just be the first to market and we'll get our advantage that way. The competition, sooner or later, if this is a successful product, will undercut you sooner or later. You also have the risk of third parties who develop the same technology independently of you enforce their own rights. And I think technology, the argument, oh, this technology is going to be superseded so quickly, there's no point in placing patents on it. And if we look at the iPhones and the iPads and that simple swipe mechanism, that was patented by Apple, and it was patented some time ago on their first iPhone, I think it was, that came up. Now that's the technology is being superseded in communications and IT all the time, but that simple mechanism that's the subject of the patent, the swipe function on the phones, is still there. So I think the lesson is to be careful about what technology is being superseded and becomes redundant, because a lot of it doesn't. A lot of the actual components of what's being done doesn't become superseded and redundant as quickly as you might think. So you have to make an informed decision and strategize as to where is best to make those decisions to patent or not. Okay, I'd also say that, look, if you're not going to file a patent purely on the basis that, well, look, we're never going to enforce this patent, so what's the point? We don't have the resources to do that. I think that's an ill-conceived way and very short-sighted view of how a patent can be used. Many years ago, I started working for a small oil and gas firm in West Perth, and that was one of the first things that they said to me, Mary, we want patents on our technology, not because we want to enforce them. We're never going to be able to afford to enforce our patents in the courts. But they were moving into an oil and gas area where, as a smaller player, they had very little market credibility. And they saw their patent portfolio as being an incredible marketing tool for them to gain credibility in the market and to attract investment. Well, at the beginning of 2014, that particular company, really on the basis of their IP portfolio alone, because they didn't have any assets anywhere else, they became a $1 billion market cap company on the basis of US investors coming in and commercializing their technology in Louisiana. So that's one of my biggest success stories, and I think a great example of a very broad-minded and commercially astute mindset with respect to patents and their use. At the end of the day, very few patents are enforced through the courts, but many more are used as deterrents and as these commercial tools to attract investors, attract collaborators, to generate revenue through licensing and sale, as negotiating tools and marketing tools. That's where the real value lies. Okay, just quickly some common mistakes. First and foremost, chain of entitlement. It's very, very important to correctly list your inventors, and I think to have clear ownership in agreements, particularly if you're collaborating with different parties. It can be a minefield later on where you've got investors looking at investing in your company on the basis of your IP, and then somebody puts their hand up as being potentially an owner and having a claim to your patent portfolio. One thing I would warn against is too many applicants being named on a patent application. Under Australian law, and it's fairly harmonious with other laws elsewhere around the world, individual co-owners of patents can exploit the invention independently of one another. So they can actually act in competition to one another. It's very messy in practice. There has to be some clear guidelines of who is responsible for ongoing payments in respect to renewals and maintenance of the patents, in making the decisions, particularly if the patent has been enforced. So we generally think it's better almost if there are many parties who've contributed to the invention, that it's almost better to form a company that forms the applicant, the holding company for the IP, and then the many contributors are shareholders in that holding company. You work it in that particular way. Publishing or commercializing your invention before you filed a patent can be fatal in some cases, depending upon how long ago you published the invention or used the invention in a commercial sense. There are grace periods, short grace periods in some countries that are available, but not in others. So publishing before filing a patent application is also one of those common mistakes that you want to avoid. Also, not doing some preliminary patent searching. I think it's always prudent for people who are engaged in R&D to check the patent register, not only to obtain additional information about the technology itself, but to check whether indeed you may be infringing somebody else's rights, particularly if you're going to invest a lot of CapEx into a particular project. Another common mistake is to publish improvements after filing a provisional patent application. You must keep your patent attorney informed about any improvements, because they can be included in a complete patent application down the track, or even be the subject of later patent applications. The worst thing you can do is publish those improvements and then they not be covered by anything at all. You've lost value in that way. It's insufficient enablement. As I've said before, this is the Achilles heel in a lot of patent applications, that insufficient information about the invention is included, and statements in the patent specification which affect the patentability of future inventions. And this is often the case where you think, well, look, there's these other great ideas and applications where it could be applied. Let's talk about that now. But it's actually too early in the development of that if you leave those statements out, you leave open the possibility that you could develop the technology further and make them the subject of patent applications in the future once the technology is developed. But you may actually be shooting yourself in the foot by making too early a suggestion. Okay, the final point I want to make is that really there has to be alignment of your patenting strategy with your commercial strategy. And if you can't tell me what your commercial strategy is, then it's very difficult to assist with advice in relation to an appropriate intellectual property strategy. And I think, you know, in these times, we've all realised that your commercial strategy can change and pivot through a whole lot of different factors in the space of a week. And it means sometimes your IP strategy is going to need to change with it. So the outcomes that you had in mind initially, perhaps you won't be able to achieve those because of the commercial factors that are raining in on you at the particular time. But I think to obtain the optimum value from your IP strategy, you must align it right from the beginning with your commercial strategy and work in partnership with your IP advisors so that they adapt and realign that IP strategy as your commercial strategy grows and changes as well. Okay, really that's all I've got at the moment, and I look forward to some questions from you, if there are any. Okay. Oh, one question. Great. Oh, thank you, Chris. Thank you very much for your kind words. All right, well, look, thank you all very much for coming. If you have any questions, please don't hesitate to give me a call or contact Helen or Beck, who organised the webinars in the first place. And I wish you a great day for the rest of the day. All the best. Bye-bye.